Hello everyone, my name is Tavik and you are watching YouTube channel of Legal Eagle. In the last video, we studied about Article 15 of the Indian Constitution, which prohibits discriminations on the basis of religion, race, caste, sex and place of birth, and in the matter of reservation in educational institutions. Today, we are reading Article 16 of the Indian Constitution, which is more or less same as the Article 15, but it refers to reservation in public employment within an office or office of a state. So Article 16 states that equality of opportunity in matters of public employment. What kind of employment? Public employment, which means an employment within a state, within the territory of India. Reservation in those kinds of employment. Article 16 clause 1 states that there shall be equality of opportunity for all citizens. Yes, as we read in last class, 15, 16, 19, 29 and 30 are articles which applies only to citizens. So, this article 16 clause 1 states that there shall be equality of opportunity for all citizens in matters of public employment within office under a state. Now, we all know what is state. State only refers to matters of employment within a state. Again, article 16 clause 2 states that no citizen on grounds of religion, race, caste, sex and place of birth, same as article 15, but it has two extra grounds which are descent and residence, be ineligible or discriminated in respect of employment or office under state. Whatever it states, that 16 clause 2 states that there shall be no discrimination in matters of public employment or an office within a state on 7 grounds. Yes, on the basis of religion, race, caste, sex, place of birth, descent and residence. On these grounds, there shall be no discrimination among citizens in the matters of public employment. अगर कोई आदमी कोई जॉब करना चाहता है, स्टेट में कोई जॉब निकली है, तो इन सारे ग्राउंड्स के बेसिस पे डिस्क्रिमिनेशन नहीं हो सकता है. आर्टिकल 15 में 5 ग्राउंड्स दिए हुए थे, इसमें 2 ग्राउंड एक्स्ट्रा एडेड, 2 extra grounds have been added, descent and residence. Now coming to Article 16 clause 3, which states that nothing in this article shall prevent Parliament from making any law prescribing in regard to a class or classes of employment or appointment to an office under the government of or any local or other authority within a state or union territory any requirement as to residence within that state or union territory prior to such employment or appointment. So, it's a lamba article, the article is very long. Let me tell you in very brief and easily explain this article 16 clause 3. It makes an exception in the matters of public employment. It gives power to Parliament to make laws to relax the condition on the basis of residence. Yes, it gives power to Parliament to make laws so that on the basis of residence, Parliament can give reservation to those people who are backward and not adequately represented in the state. Article 16 clause 3 is an exception to Article 16 clause 2, which provides exception for reservation on the basis of residence to class of person. You know, intelligible differentia, Article 14, reasonable classification. So, if there is a class of person who are backward and not adequately represented in the employment of state, Article 16 clause 3 gives power to Parliament to make laws to provide reservation on the basis of residence. If, for example, MP or Bihar has some vacancies and people apply in Bihar and also people from MP apply in Bihar. So, if a certain class of people are not adequately represented in Bihar, then that state, Bihar, can give reservation on the basis of residence. It can say that yes, these particular people are not adequately represented, so we will be providing reservation to candidates from Bihar and will reserve some seats for the candidates belonging to Bihar only. So, this was whole Article 16.3. State can provide reservation on the basis of residence. It can make a criteria that yes, we will only select people from the state of Bihar, but only if they are backward and not adequately represented in the state of Bihar or a particular state. So, this was all about. It's a lamba article, the article is very long. But in short, it is the exception to Article 16 Clause 2, which states that there shall be no discrimination on the basis of religion, race, caste, sex, place of birth, descent and residence. Then Article 16.3 is an exception to Article 16 Clause 2, which makes an exception and provides reservation on the basis of residence in the matters of employment within a state to those people, those class of people who are not adequately represented and are backward. The next clause in Article 16, Clause 4, provides reservation of appointment or post in favor of backward classes of citizens which in the opinion of state is not adequately represented under the state. So from this clause we can understand that reservation cannot be asked as a matter of right. The reservation can only be given when the state thinks that particular. As per Article 16.4, we can understand that reservation cannot be claimed as a matter of right. The reservation can only be claimed when the state thinks that particular section or a particular section of a citizen are backward and they are not adequately represented in the employment within the state. If a state has a particular number of cadre, a number of public servants who are working under the state, and the backward class of citizen are adequately represented, there are enough number of people in the employment, then state will not provide reservation. But if the state thinks that there is a need to provide reservation to certain classes of people who are not adequately represented within the employment of the state, then Article 16.4 provides opportunity to state to allow Parliament to make laws to provide reservation to those classes of people. Just like in Article 15, it allows state to make laws for the reservation of socially and educationally backward classes of citizens in the matter of admission to educational institution. Article 16.4 also allows state to make laws for those people who are backward and are not adequately represented within the employment within the state. The next clause, Article 16.4a, which provides reservation in promotion, which was added by 77th Amendment Act. Now, Article 16.4 was basically provided for reservation in initial employment. Like first employment, there can be reservation on the basis of, residence, or if any person is from backward community, then state may provide reservation if they are not adequately represented. But the question came up, can reservation also be provided in promotions? So this question was, there came up in the court, can reservation be also provided in promotion? A case came up for consideration, Indra Sawhney versus Union of India 1993. In this case, few questions came up for consideration, that whether Article 16.4 is constitutional or not. So it was held that yes, Article 16.4 is constitutional and state can provide reservation in matters of employment within the state on the basis of backwardness of a citizen if they are not adequately represented. But it made certain observation or made certain key points to remember. Firstly, it stated that there can be more backwardness. It held that in a backward class of society or backward class of citizen, there can be a differentiation or a classification of more backwardness. It introduced the concept of creamy layer. It means that those classes of socially and educationally backward of classes of people who are no more backward or have gained certain amount of forwardness in their living, in their education, in their way of living, then they will be considered as creamy layer and they will not be eligible for reservation. Also, it held that there can be no reservation in promotion. It also held that there should be 50% ceiling in matters of reservation. It also held that the reservation or the discrimination cannot be on sole economic criteria. It means that only economic criteria will not define the backwardness. The backwardness should be social and educational both. the backwardness should be both social and educational, and only economic backwardness will not allow for reservation under Article 16 or Article 15. As we read in Indira Sawhney versus Union of India, it held that there shall be no reservation in matters of promotion within employment. But the Parliament, by the 77th Amendment Act, added clause 4A in Article 16, which stated that there can be reservation in matters of promotions. Now again, by the 85th Amendment Act, the Parliament added in clause 4A consequential seniority. What does consequential seniority means? For this we have to understand first the catch-up rule. It stated that when two people are on the same post or same rank in an employment, and one other person who has reservation, who belongs to a backward community, and the state thinks that he should be given reservation in matters of promotion because they are not adequately represented in the employment of the state at that rank, the state may give promotion to that particular person. Now, if A and B are two people who are working at the same rank, and B is from reserve category, and he gets promoted here, B. Now, after working 2 years, A's time for promotion also came, and A get a promotion, and now A and B are both on the same ranks. B is 2 years senior, but now, as per catch-up rule, both A and B will be at the same rank and hold the same position, draw the same salary. Okay, this is the rule as a catch-up rule. But in the next promotion, A might get promotion first and B might get promotion later. But in the consequential seniority, if A and B are two people, okay, they are holding same rank, same position, and B gets promotion earlier because he belongs to a reserve category and this person belongs to a general category, and after 2 years A also gets promotion. So as per consequential seniority, B will always remain senior as B got promotion earlier from A, and A and B will not be considered for promotion or will not be considered equal, as there is a consequential seniority as per 85th Amendment Act. So we understand through catch-up rule, A and B both same, working on the same rank. Okay, B is from reserve category, A is from general category. B gets promotion. 2 years he works. After 2 years, A also gets promotion, and A and B will again be same, and B will not be senior to A. But consequential seniority states that if B gets promotion earlier due to reservation, B will remain senior to A, and A will be junior to B because B got promotion earlier. So this is the meaning of consequential seniority, and we understand what is catch-up rule and what is consequential seniority. Catch-up means A will catch up to B, and consequential seniority means B will always remain senior to A. Let us understand the chronology. आप chronology समझिए. सबसे पहले Kelkar Commission was appointed in 1953 under Article 340, Clause 1 of the Indian Constitution. This Kelkar Commission was popularly known as Kaka Kelkar Commission. This commission was set up to identify methods of improving the conditions of socially and educationally backward classes. This was the first ever commission which was set up to identify the socially and educationally backward classes and also to identify the solutions for the upliftment of socially and educationally backward classes. The second commission which was set up in 1979 was Mandal Commission. This commission was headed by B.P. Mandal. Mandal Commission was set up under Article 340 of the Indian Constitution. So, what was the goal of the Mandal Commission? It was to define socially and educationally backward classes, to define who all consist of socially and educationally backward classes. And Mandal Commission identified that 52% of the population of India, which consists of 3,743 castes, are SEBC, that is socially and educationally backward classes. So out of the all 100% population, 52%, more than 50% of the population was actually socially and educationally backward. This was the finding of Mandal Commission. And what did it recommend? It recommended 27% reservation for socially and educationally backward classes, in addition to already 22.5% reservation which was available to scheduled caste and scheduled tribes. On the recommendation of Mandal Commission, Prime Minister VP Singh, which was the then Prime Minister of India, issued a memorandum on 13th of August 1990 reserving 27% seats for socially and educationally backwards as OBC reservation. So the OBC reservation which we see today is the result of the findings of Mandal Commission and its recommendation. In the case of S. Vinod Kumar versus Union of India, the court held that relaxation in qualifying marks for promotion, it held that relaxation in qualifying marks for reservation in promotion was not permissible as it infringed Article 335 of the Indian Constitution. In the case of S. Vinod Kumar versus Union of India, it was held that relaxation in qualifying marks in reservation for promotion it was held that relaxation in qualifying marks in reservation for promotion is not permissible under Article 16 clause 4. The 16 clause 4 only makes provision for reservation in matters of employment to backward classes of citizens who are not adequately represented in their state, as we read earlier. In this case, it was held that there shall be no relaxation in qualifying marks for matters in promotions, which was not permissible under Article 16(4) because it will get hit by Article 335 of the Indian Constitution, which states that administrative efficiency of a state body or an office should not be hampered by giving reservation in matters of promotion. As we read in the previous case, S. Vinod Kumar versus Union of India, it was held that relaxation cannot be given in qualifying marks for promotion, for giving reservation in promotion in public employment. But state brought an amendment, the 81st Amendment Act in 2000, which overturned that judgment and held that it added Article 16 clause 4b 16 clause 4b to Article 16, which allowed reservation in promotion. So Article 16 4b was added in Article 16, which allowed reservation in promotion, which negated the S. Vinod Kumar versus Union of India judgment. And also it allowed to breach 50% ceiling, as we read earlier, that the reservation should not exceed 50%. But this amendment also made it possible to breach the 50% ceiling. Lastly, the amendment also allowed the carry forward unfilled vacancies. Also to carry forward unfilled vacancies. What are carry forward unfilled vacancies? It means that if there were 50 posts in 2023 and only 40 got filled, okay, so 10 seats got left, then if a vacancy comes in 2024, suppose another 50 vacancy came up, then state can consider these 10 vacancy in addition to the current 50 vacancy which came up. So this is carry forward rule. This unfilled seats will carry forward and added to this new vacancy. The 16(4)(b), Article 16(4)(b), which was added through 81st Amendment, also allowed to carry forward unfilled vacancies in the next year vacancy. For example, if 2023 there was 50 vacancies available and only 40 got filled and 10 remained unfilled, then this 10 will get carry forward in next year vacancies and this will be added to the new vacancies, which is now 50 plus 10. The reservation will be provided on the entire number of vacancies, which was not earlier possible. Only reservation could be given on this vacancy, not this vacancy. So 16(4)(b) also made it possible to carry forward unfilled vacancies in the next year vacancy. That reservation should not be such that the efficiency of administration is hampered. Okay, the efficiency of the office, the efficiency of the administration, the working of the administration in such higher institution or state offices should not get hampered by less deserving candidates who get promoted. So, in Article 335, it is about claims of SC/ST, which is the claim of SC/ST to get reservation if they are not adequately represented in the office of the state versus efficiency of administration. The court held in S. Vinod Kumar versus Union of India that the claims of SC/ST should not hamper the efficiency of administration of the office. But through 82nd Amendment Act 2000, the Parliament added a proviso to Article 335 which allowed relaxation in qualifying marks for reservation in promotion. तो आर्टिकल 335 के जो प्रोवाइजो ऐड हुआ 82nd अमेंडमेंट एक्ट से, उसमें एक प्रोवाइजो डाल दिया गया जिसमें रिलैक्सेशन दे दिया गया मार्क्स में टू फॉर SCs and STs to get reservation in promotion. So this made it easier for government to provide reservation to SCs and STs, considering that the efficiency of administration is not hampered. So as we read earlier, the claim of SCs and ST are not absolute. It is subject to efficiency of administration and subject to that they are not adequately represented within the office of the state. Through the 85th Amendment Act, which was brought in 2001, the Parliament negated the rule which was introduced in Veerpal Singh case, which held that there will be a catch-up rule. Now, the Parliament negated the catch-up rule and introduced consequential seniority to promoted SCs and ST. We have understood already what is catch-up rule and what is consequential seniority. Catch-up rules means if A is junior and B is senior, A is junior to B and B is senior. A belongs to a reserve category and gets promotion. Now, A is senior to B. Then B, a senior, will again get reservation and will be here along with A. Now, through catch-up rule, B will catch up to A and will not be any more junior to A and will be at par with A. But in consequential seniority, what happens? That if A belongs to a reserve category and B belongs to general category and A is junior to B, A gets promotion due to reservation and becomes senior. B, a general category, gets promotion and now becomes senior, but here A will remain senior to B. This is consequential seniority. One who becomes senior first will remain senior, and one who becomes senior or promoted later will remain junior to the one who will be promoted earlier. So this is consequential seniority. In M. Nagaraj versus Union of India, the 77th, 81st, 82nd, 85th amendment were challenged. But the court held that all these amendments are valid. There can be reservation in promotion. But it held that there are 3 points which the states need to prove. That there is backwardness, first point, and they are not adequately represented. In the state services, and the efficiency of administration is not hampered. If the state can fulfill these conditions, that there is backwardness, there is not adequate representation of these backward classes in the office of state, and also efficiency of administration is not hampered, which is given under Article 335, then the state can provide reservation in promotion with consequential seniority. In Jarnail Singh versus Lakshmi Narayan Gupta, which was decided in 2018, it held that the judgment given in Nagaraj does not need reconsideration. The 77th Amendment, 81st Amendment, 82nd Amendment and 85th Amendment are all valid. The Nagaraj judgment need not need reconsideration, and it also held that the criteria for further backwardness is not necessary. But it added that the creamy layer concept, which was given in Indra Sawhney versus Union of India, will extend to SCs and ST also, the creamy layer, which means those people who belong to SC/ST but come under the creamy layer will not get reservation. This was held in Jarnail Singh versus Lakshmi Narayan Gupta. In B.K. Pavitra versus Union of India in 2019, the court upheld the 2018 Karnataka Reservation Act, stating that state has sufficiently proved that there is a SC and ST community which are backward and they are inadequately represented. The state of Karnataka was successful in proving that there is a backwardness of SCs and ST in the state and they are inadequately represented in the office of the state. And thirdly, that there is no effect on efficiency of administration. So these 3 points were proved, which was held in Jarnail Singh and also in the previous judgment of M. Nagaraj, that these 3 points the state should prove, and the state was successful in proving these 3 points. So court upheld the 2018 Karnataka Reservation Act. In 2021, Maharashtra government decided to give reservation to Maratha community. In Jayshree Lakshman Rao Patil versus CM of Maharashtra, this reservation was challenged. Now the issues which arise, that can there be more than 50% reservation? Already the state of Maharashtra had given reservation to various socially and educationally backward classes. Now by introducing reservation to Maratha, this 50% ceiling was being breached. And the second issue was the state has power to identify SCBC. So the court held that there is no reason to give reservation to Maratha as there are already reservation. So this was held in negative, that no 50% reservation ceiling cannot be breached. And also through Article 342A, which was added by 102nd Amendment Act, it held that state does not have power to identify SEBC, socially and educationally backward classes. 102nd Amendment Act states that state does not have the power to identify SEBC. But the 127th Amendment Act has given the power to various states to identify SEBC, and a commission was set up, National Commission for Backward Classes, under 122nd Amendment Act. The state now has power to identify, along with center, the state also has now power to identify SEBC. This was all about Article 16 of the Indian Constitution. If you liked the video, give it a thumbs up and subscribe to my channel Legal Eagle for more such videos, and happy learning.